Good afternoon, Your Honors.
Good afternoon.
May it please the Court, my name is Leah Jamilova. I represent the appellants. This case is about how the BIA reads the matter of Appellant about administrative closure. The BIA reads it time and time again, and in this case as well, to be only about one factor, whether or not a person has either concurrently pending application with CIS or immediately available application with a CIS. They ignore completely the rest of the factors in the case. And they ignore the matter of Appellant that says that this is one of the factors, not explicitly all the factors. The government seems to support that because in their brief, they also only address this factor and nothing else. Also, the DHS would like us to believe that this case is about discretion. However, we do not argue that BIA does not have discretion in this case. It's absolutely their discretion. We are arguing how do they read the law about the discretion and apply it to the facts of the case. Because just the cursory line that we took into consideration all the factors is not sufficient because we have no idea what they did with it. We have no idea about their analysis, and that leaves the door open for abuse of discretion.
So, I'm sorry, I think you said at the beginning that they only considered one factor. Because as I look at the board's decision, there's mention of several of the factors. So which is the one that you think they looked at?
They mentioned them. They only considered one factor, whether or not the I-130 that the family petition that the children will file when they're 21, whether or not it's sufficient for admin closure. And they find it speculative, and they find it to be too remote in time. The rest, they just mention. That's it. They don't give them any consideration.
Well, I'm sorry, how do we, what is the distinction you're drawing between mentioning and giving consideration to? How do we know, notwithstanding the fact that they said something about it, that they weren't considering it?
If in their decision they say because this I-130 is too remote in time and too speculative, we deny admin closure, then I do believe they did not consider the rest of the factors.
But you could, you can have a multi-factor balancing test where you, in the particular circumstances of a case, one of the factors is particularly important, and that's the one that drives the decision. And you can say, there's factor A, factor B, factor C. Because of factor D, we conclude whatever we conclude. That doesn't mean you're not applying the factors, does it?
Absolutely. However, the only way we can infer what they did or did not consider is their decision, right? The discussion in their decision. So if in their decision I do not see the discussion about the fact that she is afraid to go back, the factor that we raised in the motion to admin close, if they do not address the fact that she has two USC children who are 7 and 4 and who will become 21 and petition for her, if they don't address the fact that she doesn't have criminal history, that she's not a security risk under the DHS guidelines, then all the factors...
Wait, which of the... Are you talking about the factors under Appellant?
Yes.
But so we're those last couple things I don't...
I understand it. It was confusing. So we have matter of Appellant, right? That lists the factors for us and says these are not exhaustive. You can consider other facts in the case, other factors in the case. So when we raise admin closure, these are the factors that we raised in favor of the admin closure.
So,
And those
Counsel,
are,
have you discussed mediation with the government? What I found striking about this is that DHS didn't respond to the appeal or to the motion at all. And I'm just wondering if you reached out, given the fact that you do have, your client does have this U.S. citizen children. She's clearly evidenced her fear of persecution if returned. I'm just wondering, did you go to mediation? Do you want to go to mediation? Have you gone, and did it not succeed?
we asked for admin closure from oil as well. And they said this is not the case that's going to merit it. So that was the end.
So, but then they didn't oppose your motion.
No, at the stage of the BIA, they did not oppose the motion, but there is no mediation available at that stage. However, here, when we are already at the Ninth Circuit, we did reach out to OIL and we asked, can we admin close at the Ninth Circuit stage for the same reason, to wait until children petition for her. And they advised us this is not the case that they would do it in. In the opposite, they fighting this case, which is odd to me because they didn't fight it at the BA stage. They didn't really care because they didn't respond at all. But here they do fight it. So, however, this is not surprising. The DHS and the government, they always have strikingly different policies. They change every year. And that's one of the problems that we have with this case. Because EOIR changes policy about Avitisian.
Well, and OIL is representing DHS.
Yes.
So if DHS doesn't oppose the administrative closure, and the counsel for DHS has to do what DHS wants, not what it wants, so.
Well, but at this stage, OIL is defending the position of the Attorney General as reflected by the board, right?
Exactly.
Okay.
Yes. But the problem is so the matter of Avitisian and the admin closure is problematic from the beginning. Not from the beginning, let's say 2012. That's when the whole back and forth started, right? Yes, admin closure 2012. No, admin closure 2018. Yes, admin closure 2021. And the DHS changes policies every year. If this case right now was before an IJ, the NTA is deficient, and the BI already said the government cannot cure this deficiency, this case would be dismissed.
Why is the NTA deficient?
It doesn't state the date and time of the hearing as it's supposed to per regulations. And recent BIA case stated that they cannot cure that by filing subsequent notice of the hearing.
But did you raise that issue before the agency?
No, the rule changed after the BIA case was already concluded, and also at the BIA stage, they would not be able to go back and consider because pleadings were already done.
Okay. But, and you didn't raise it in your brief before
No,
us?
again, it happened afterwards. We have it changing every day.
But at the time of the hearing before the BIA, the rule of the BIA was that the most important factor was whether there is an opposition to it.
Yep.
That the BIA, and did the BIA, how did they?
The BIA said, even though the DHS did not file a response, we still deny. So they did it contrary to the law, actually.
So did they give a reason why?
No?
Well, I mean, they identified some of the other factors, right?
Yeah, they go back again to the same petition by the USC kids. And also they claim that this is speculative. So let's look at it. We have 2 biological U.S. citizen kids. Is it a fact? Yes, it is a fact. It's not a speculation. Are the kids going to be 21 at some point? Yes, absent
That point is 15 years from now?
14?
Well, from the time of the...
Yes,
Okay.
it was 15, yes, at that time. I would agree with them that this is so remote in time, except for when we look at the processing times by the EOIR, it's the same, more or less, time. We have cases that are pending for 10, 20 years. So with that, for them to claim that this is too remote in time, kind of not fair.
I mean, it's a little odd to say that because the agency is, because the adjudicative process is slow, that therefore they should be prohibited from doing anything to try to move cases along.
No, I would say this gives perspective of what is too long and what is not too long.
If we were to find that they didn't properly weigh, for example, the most important, what they've said is the most important factor, the answer then is to remand for them to reconsider the factors.
Would be procedurally correct, yes. I think I will preserve whatever I have left for the rebuttal.
Okay, thank you.
Good morning. May it please the court, this is Dana Camilleri for the Attorney General. At the outset, I just want to clear up a couple of things. The request for JAC happened after this was calendared for oral argument, and under SARCAR, we are not
The request for JAC?
judicial administrative closure before this court, which was just referenced by opposing counsel, and that's why it was rejected. In terms of what the board did here, it acted within its broad discretion and reviewed its unexhaustive list for matter of Abbottesian and WYU and decided that this was not the case, that it should be administratively closed. That is a docketing tool, and they have broad discretion to look at the factors and determine whether it merits administrative closure. And
Can you
this-
tell me where they considered what WYU directs, that that being the most important factor? Where did they analyze and say why? Or did they even acknowledge that the government didn't oppose administrative closure?
They noted it, and on the 5th page of the decision, they note that DHS has neither joined nor responded. The fact
That's
that
not
they
the
didn't,
same as acknowledging that they didn't oppose, right?
well, Your Honor, DHS can actively join in a motion to administratively close. They don't respond to every single request because that would be overwhelming for that agency. But the board has the authority to administratively close, and really, they're the ones that get to look at the factors.
Well, what do the regulations say about if DHS or a petitioner doesn't file a timely opposition to a motion to administratively close? How is the BIA supposed to consider that?
Your Honor, I don't believe there's anything in the regulations, and I would actually argue that I'm not even sure she raised this in her brief.
It's in there, it's cited in it, and it's 8 CFR 1003.2 G3, which specifically says, it's cited in her brief, that if it's not opposed, I think it's within 13 days, then the board shall deem it unopposed. Not just that they didn't respond or they neither joined, but it's supposed to be deemed as not opposing. And doesn't WYU say that that's the most important factor?
But, I'm sorry, Your Honor, are you saying that in every administrative closure case, the board, that the DHS does not respond to, the board needs to then say that it's unopposed and grant closure?
No, they don't have to grant it. Of course not. They don't have to
They
grant
acknowledged
it.
it, but they also acknowledged that there are other serious factors that are at play here. I mean, this court itself in Ianian very recently refused to put a case of mediation with an approved I-130 petition, which we are nowhere close to that here, because of the processing times and how long it would sit on this court's docket. The board is entitled to have similar conclusions, particularly when faced with this 15, 16-year, then they have to petition, then that needs to be processed, there needs to be a visa. And in terms of bringing up her asylum claim, she completely abandoned those claims before the agency, so why would they consider that?
I'm just focusing on WYU says that it is the most important factor, right? That's what it says, and that is now, again, it's gone back and forth. It's now in place, right, and supposed to be followed. And so how do I look at this decision and see that the BIA followed that directive and said, even though it's the most important factor, and we acknowledge that it's deemed unopposed, not just neither joined nor responded, as the regulation says, a motion shall be deemed unopposed unless a timely response is made. How do I see from this that it actually considered it and said, notwithstanding the fact it's unopposed, we believe these other factors outweigh it? Not that they couldn't, maybe they could, but the question is, did they do that?
Your Honor, just because they didn't use the exact language that you're discussing does not mean that they did not follow the factors. I think it's very clear that they outlined what the factors are. They acknowledged DHS neither opposed nor responded, but they discussed why the other factors were important and why, in this case, within their discretion. I mean, this is being reviewed for abuse of discretion. And our position is that it is absolutely not abuse of discretion for them to lay out the factors and decide that in this particular circumstance, the protracted period of time is enough. And in fact, that was conceded. She said it was a remote in time possibility for relief in her request for administrative closure to the board.
How do we know that the board considered that under WYU it's the most important factor? Did they recite that?
Your Honor, they cite WYU extensively, and then they note at the end that DHS has neither joined nor responded, but still say, under the circumstances presented here, we will deny the motion for administrative closure.
They cite it for discussing the factors set forth in matter of...
Right, that is acknowledging the factors that are in their decision.
Okay, I'm just struggling with, because WYU and even this court, the Ninth Circuit, it's not really me, but the Ninth Circuit has acknowledged that that is what it says, that it's the most important factor. I know the Seventh Circuit has reversed and remanded when it wasn't followed, at least it wasn't clear that that was the most important factor. I'm just struggling with, because they didn't anywhere in there acknowledge it's the most important factor, not one of many, but the most important. Can be overruled, no question, can be, but we have to make sure that they actually followed that and then exercise their discretion. And I'm-
Language that would have been useful in resolving this is if they had said, this is the most important factor, but we find these other factors outweigh that factor in this instance.
Sure, we could go back and forth about how
No,
board
I don't-
decisions
no,
are
no.
inartful at times.
Counsel, we're not arguing with you. We're
Yeah,
trying to
I
get
just,
to the
this
bottom
is
of
actually
the-
a pretty thorough board decision.
Just interrupted me, counsel.
sorry, Your Honor.
Yes, really. I'm just trying to get to the bottom of this, to try to figure out if they did follow this case. What did the board acknowledge that it was deemed unopposed? I mean, I'm not sure it was the wisest thing to file this motion for administrative closure instead of appealing on the merits of this case. And I don't mean any disrespect to counsel, but I'm just looking at it as a whole. But I mean, I just don't, I tend not to clearly see the weighing of factors that my colleague is discussing in this opinion. And what is the harm with remanding to have them really apply the factors? And also, this is another question that's lingering. The fact that it was deemed unopposed, could DHS come back in and say, well, now we oppose it?
I'm honestly not sure, probably. I assume there would be another round of briefing if you remanded it.
Well, it also strikes me that it seems sort of unfair that the merits of this case were never briefed.
That was a
I know, I
litigation
realize that.
strategy.
I
I can't
realize
even
that.
speak to that.
If we conclude that the board's opinion is ambiguous as to whether the board correctly understood the two precedents that it cited or incorrectly understood them, what conclusion should we draw?
Well, Your Honors, I really think with the standard of review being abuse of discretion, that is a very high hurdle to send it back down to
Well,
the board.
abuse of discretion also means error of law.
I mean, isn't the answer that we presume that the board has correctly applied the law absent some indication in the opinion that it didn't?
Yes, that's correct. Are there any further questions for me?
I don't have any more.
Thank you.
Your Honors, what you've heard right now is what we hear on a daily basis in court, in immigration court. DHS is too busy. The court is too busy. However, we have people's lives on the line. We have safety of these two U.S. citizen children. We have future of this person who is not a danger to anyone. So to not do their job properly just because they're too busy is not fair. It's just not fair under due process or just a human understanding of fair. Also, you cannot just go back. Before you didn't oppose, now you changed your mind and you opposed. I would say that's abuse of discretion, even though DHS does not have discretion in the legal meaning of that term. But that shows you that they can do whatever they want in immigration proceedings, and that's what we have to deal with every day. Thank you, Your Honors.
All right, thank you, counsel.